Hello, my name is Olivia Deans, and I am an Ocean and Coastal Law Fellow with the National Sea Grant Law Center at the University of Mississippi. And my co-author is Catherine Janessi, who is the Senior Research Counsel at the National Sea Grant Law Center. I will be presenting on PFAS legal and regulatory updates. For this presentation, I will be discussing the regulation of PFAS and give an overview of federal and state regulation, and I'm going to be focusing on states in the Great Lakes region. So I will begin with federal regulation and discuss the mechanisms or avenues that are available for federal actions that might regulate PFAS. And then I'll also go over the history of federal regulations and what actions an agency has taken or may take, and the status of where we are right now. Next, I'll be discussing state regulation, starting with the authority and ability of states to regulate emerging contaminants. And I've selected 3 states, Minnesota, Michigan, and New York, to discuss how those states have regulated PFAS, and I think these illustrate different approaches that are available. So, as you may know from other presentations or your background on emerging contaminants, PFAS are a family of emerging contaminants, and PFAS includes hundreds of individual compounds. So the 3 main compounds I'll probably mention throughout this presentation are PFAS, PFOA, and PFOS. And these compounds are troublesome because they accumulate in the environment and they're difficult to break down. And these compounds have been linked to various health issues. So at the Law Center, we are interested in PFAS contamination, specifically when it applies to drinking water or groundwater. And so this is a recent map from January 2021 that shows where communities have tested and found the presence of PFAS contamination in drinking water. And as we continue testing more and more, there are more sites that are being identified for PFAS contamination. So this is just kind of the tip of the iceberg of how we're learning about how these compounds get into our water sources. So turning to federal regulation, there are many different mechanisms that the federal government can use and has been using to regulate PFAS. And that authority can come from many different statutes. So I'll give just a brief overview of what those statutes are. So the first is the Safe Drinking Water Act, and this act regulates standards for public drinking water sources in order to protect the public health. And under this act, the EPA has the authority to regulate water contaminants in sources of drinking water. And it does this by setting a maximum contaminant level. So that means that once that contaminant level is reached, there are penalties and avenues for relief if that chemical exceeds that contaminant level. And this act also requires monitoring of drinking water. And another action EPA may take under this standard is to set health advisories. And I'd like to just point out that it's important to note that health advisories are not binding. They're recommendations, so there's not necessarily a penalty under the statute for exceeding them. The second statute, and probably one of the most well-known, is the Clean Water Act. And the Clean Water Act regulates the discharge of pollutants by humans into federal waters. So under the CWA, or the Clean Water Act, the EPA has authority to set limitations on a pollutant that specifies a level of permissible discharge. And this standard is set at a reduction level that may be achieved by the best available technology or a similar standard. The next mechanism for federal regulation is the Toxic Substances Control Act, or TSCA. And under TSCA, the EPA might regulate PFAS through what is called the Significant New Use Rule. And under this rule, if the EPA classifies a chemical use as a significant new use, then that requires monitoring, review, and notice requirements about how the compound might affect humans. Next is the Comprehensive Environmental Response, Compensation, and Liability Act. And this statute provides federal funds to clean up sites of contaminants in the environment. So, for example, EPA could set guidelines for remediating groundwater that's been contaminated with PFAS at CERCLA sites. And then finally, another mechanism that might not always be first thought of could be the Clean Air Act. And under the Clean Air Act, EPA has authority to designate hazardous air pollutants for chemicals that might have human health impacts. So next, turning to the status of federal PFAS regulation. To start with, it's important to note that the federal government has not comprehensively regulated PFAS, and it's really only been the last few years that EPA has started to begin this regulation process. So taking a step back, actually, back in 2002, the EPA began a priority review of PFAS, where the agency invited companies, I believe there were 8 major companies, to phase out PFOA and PFOS. And all 8 companies complied and did begin phasing out those types of PFAS. But it kind of changed manufacturing techniques, and so there's still companies emitting a different type of PFAS. In 2016, EPA established health advisories for PFOA and PFOS under the Safe Drinking Water Act. And so, as I mentioned earlier, health advisories are non-binding, so there's not a lot of teeth to those rules, so it doesn't require a state to take affirmative steps. Then a couple of years ago, in 2019, EPA released a PFAS action plan. And this was a plan that invited public comments on how the agency should categorize and regulate PFAS and what sort of scientific information was needed. So EPA released this plan in 2019, and then in 2020 began taking steps under that plan. So in February, the EPA proposed regulating PFOA and PFOS under the Safe Drinking Water Act, and not just as a health advisory, but as a binding maximum contaminant level. Then in June of 2020, EPA proposed a significant new use rule under TSCA, and as a reminder, this would require notice and reporting requirements from companies using PFAS in manufacturing. Then in December of 2020, EPA released guidance, so again, not binding yet, for PFAS disposal under the National Defense Authorization Act. And then in 2021, and kind of one of the most comprehensive steps that the agency has taken, EPA issued notice that it was controlling data for collecting data for what the limitation guidelines and performance standards should be set for PFAS under the Clean Water Act. In the past year, EPA has continued to propose new rules, strategies, and final rules regarding PFAS regulation. So last June, EPA published a proposed rule that would require manufacturers and importers to submit certain types of data on PFAS to the agency, to EPA. Additionally, in June, the EPA also published a proposed rule that would designate PFOA and PFOS as hazardous substances under CERCLA, which again would provide funds and guidelines for cleanups and remediation sites. Then in October, EPA published a PFAS testing strategy, and also in October, EPA announced guidance on how PFAS should be handled under RCRA, which is the Resource Conservation and Recovery Act. Then in December of 2021, the EPA published a final rule that added PFAS substances to the 5th Unregulated Contaminant Monitoring final rule. And then finally, in January of this year, 2022, 4 PFAS substances were added to the Toxics Release Inventory list. So looking forward, I think we'll continue to see some exciting proposals and final rules regarding PFAS from the EPA this year as it continues to more comprehensively regulate these compounds. All right, so now turning to state regulation. Generally, federal regulatory standards act as a floor, and states may enact stricter standards for a contaminant than the federal regulatory standards. However, in the absence of federal standards, which is kind of where we are right now, states have taken a variety of regulatory approaches, and I'll highlight some of those approaches. So a state may regulate through a statute enacted by the legislature or through regulations and rulemaking procedures conducted by a state agency. And I think this rulemaking procedure is important because it allows for public comments and inputs from stakeholders and the scientific community. I think it's also important to note that not all states have the statutory authority to regulate PFAS without significant administrative burdens that would amend state statutes. Starting with Minnesota, currently Minnesota does not have a state water quality standard set for PFAS. And this is likely because the state does not have the authority to set an enforceable maximum contaminant level, or MCL, under the Safe Drinking Water Act. However, Minnesota has issued advisory values for PFAS through its Department of Health, and those values are set at 15 parts per trillion. And like the EPA health advisories, these limits are recommendations and not necessarily binding. And so for comparison, this level is much stricter than the EPA advisory level of 70 parts per trillion. In February 2021, new legislation was introduced to address PFAS chemicals within the state as part of the Minnesota PFAS Blueprint Plan. This legislation has not yet been enacted, but if passed, Minnesota would become the second state to regulate the entire class of PFAS chemicals as a hazardous substance. Next, turning to Michigan. Michigan has taken a different approach than Minnesota and has established enforceable drinking water standards under state law. So as I note on the slide, this is different than many other state non-binding advisory limits. These limits are enforceable standards. So the agency published maximum contaminant levels, or MCLs, for 7 PFAS chemicals, and those chemicals are listed in the chart on the right on the slide there. And this rule was enacted from authority stemming from the Michigan Safe Drinking Water Act, and the final rule took effect in August 2020. And the gist of the rule is that it sets standards for the amount of contaminant that is allowed in drinking water and groundwater, and then it also requires monitoring of public water sources. And then finally, the last state I want to talk about is New York. And New York is interesting because it was the first state in 2016 to regulate PFOA as a hazardous substance. So note that for New York, a hazardous substance designation has different compliance standards than, say, the Michigan or Minnesota drinking water standards. And I would characterize these as a stricter designation in some ways, because instead of setting a limit for how much of the contaminant can be released, a hazardous substance designation requires proper storage and monitoring of a chemical, and there must be authorization to release it at all, even in small quantities. Notably, there are some exceptions to this rule, for example, firefighting foam. And then New York has also set MCLs for PFOA and PFOS at 10 parts per trillion, which is again much stricter than the EPA limit of 70 parts per trillion. There's also a current bill to regulate concentrations of PFOA in the air, but at this time it has not yet been passed. So in conclusion, there is not a comprehensive national regulation of PFAS. However, we are seeing the EPA actively engage in beginning to regulate PFAS using several different mechanisms. In the absence of federal regulation, states have taken a variety of approaches. And as I covered, some states have set advisory values and some have set enforceable drinking water standards. We will likely see stricter and more comprehensive federal regulation emerging, potentially even this year in 2022. And this federal regulation is also important to help states that might not have the authority to regulate PFAS. So the EPA has been leading the federal approach, and I suspect we will see more updates from the agency this year. Thank you so much for listening and reviewing this presentation. I've included a link to the Law Center's water webpage and also our emails in case there are any follow-up questions. Thank you.